Hello everyone, and welcome to the July 2024 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm an executive partner here at our Troy office. Our July 2024 topics will of course include a case law discussion, or case law update rather. This is a very recent to be published opinion from the Court of Appeals, Kim Bradley v. Westfield Insurance Company and American Select Insurance Company. Then we'll move on to trending topics in PIP litigation, where I want to discuss or touch a little bit on the business auto policies and what types of motions for summary disposition options you have with those policies. And this is just based upon a trend I'm seeing lately in litigation with plaintiffs' counsels regarding these business auto policies. Now, first up, we have Kim Bradley v. Westfield Insurance Company, and again, this was issued very recently on July 2024, and it's from our Court of Appeals, and it will be published. So this is a persuasive opinion. Now, ultimately, the Court of Appeals concluded that rescission of a policy is not mutual, even though the insured deposited the refund of premiums in her bank account. Now, pursuant to MCL 500-3113, recovery was not barred in an action where plaintiff operated a vehicle without a valid license. And ultimately, not having a valid license did not constitute an unlawful taking pursuant to that specific statute. Now, just a brief background on this one because it is important. Plaintiff's mother here had a no-fault insurance policy through defendant. However, defendant was not aware that it's insured. Plaintiff's mother lived with plaintiff Kim Bradley. Now, the insured allowed plaintiff Kim Bradley to drive her car fairly often, and sometime later, plaintiff was in an accident while driving in the state of Kentucky. Now, ultimately, plaintiff sought to recover PIP benefits from defendant, but defendant sought rescission of the policy, arguing that it was a misrepresentation and fraud by its insured because they were not aware that the insured lived with plaintiff. Now, defendant argued that its insured defrauded it by failing to disclose the residents in the home, i.e. plaintiff, and subsequently defendant notified its insured that it had unilaterally rescinded her policy, and defendant issued a refund for the premiums to its insured. Now, this refund check was deposited by its insured, plaintiff's mother, in her bank account. So that check was cashed by the insured. Ultimately, the trial court decided that plaintiff was not entitled to receive PIP benefits from defendant, and this appeal followed. Now, on appeal, the parties raised three issues. One, whether defendant's insured committed fraud in her application for the insurance, whether the insured agreed to a rescission by cashing the refund check or depositing it into her bank account, and three, if the rescission was proper, whether plaintiff could be considered an innocent third party and still receive coverage. Now, here, as you recall, plaintiff is the daughter of the defendant's insured. Now, in all fraud cases, it must be proven or well settled that an insured is entitled to rescind a policy on the basis of a material misrepresentation made in the application of no-fault insurance. So the material misrepresentation had to have been made at the time the insured applied for the insurance. Now, in order to justify rescission of PIP coverage with respect to pre-occurment misrepresentations, which are those policy application misrepresentations, the insurer must be able to demonstrate common law fraud under equitable principles. Now, common law fraud, the elements are 1, material misrep, 2, representation was false, 3, the person making that false misrepresentation knew it was false or acted recklessly when they made that statement, 4, the person intended that the opposing party should act upon that misrepresentation, 5, the opposing party did act upon that misrepresentation, and 6, an injury was suffered by this representation and the party's reliance on it. Now, ultimately, defendant failed to produce any evidence suggesting that its insured made a false representation, as defendant's application for insurance did not ask the applicant who lived with her and whether there were other drivers in the household. Now, it asked a ton of other questions, which the court does discuss, but it did not specifically ask the insured to disclose any other drivers in the household, nor did it ask who just lived in the household in general. Rescission, there's a mutual rescission versus unilateral rescission. Now, defendant here argued that mutual rescission was implied by acceptance of the check, refunding of the insurance premiums. So initially it was unilateral rescission when they rescinded the policy, but then it became mutual, arguably defendant's arguments, but it became mutual when the insured deposited that check for the insurance premiums into her bank account. Now, the court said that acceptance of consideration is not an effective mutual rescission unless the receiving party is fully informed of the condition accompanying acceptance. Now, here it's unless there's another insurer or someone like me cashing that check, or someone like you cashing that check, a typical layperson would not realize that the cashing of those insurance premiums means that they are accepting that rescission, means that they wouldn't know that it becomes a mutual rescission and the arguments or lack of benefits that come with that decision. So here the court said that she didn't know that, so it cannot be acceptance of consideration. Moving on to the second argument, because remember there were three things, the three issues the parties raised on the appeal: whether there was a mutual rescission, the argument of NCL 500-3113 regarding unlawful taking, and then the innocent third party issue. Now, pursuant to MCL 500-3113, a person is not entitled to be paid PIP benefits for accidental bodily injury if at the time of the accident the person was willingly operating or willingly using a motor vehicle or motorcycle that was taken unlawfully and the person knew or should have known that the motor vehicle was taken unlawfully. Now, here there was simply no argument by the insured or plaintiff that she did not have permission to take the vehicle or to drive the vehicle. But there was an argument that because plaintiff was not a properly licensed driver, that it became an unlawful taking. Now, to highlight these facts, the court discussed two cases: Monaco v. Homeowners Insurance Company and Swoop v. Citizens. Now, the court addressed the meaning of taken unlawfully in the case of Monaco. In that case, plaintiff sought PIP benefits on behalf of her 15-year-old daughter who sustained some injuries when she lost control of a car that was driving and crashed into a ditch. At the time of the crash, the daughter obtained her driver's permit but was only legally authorized to drive if accompanied by a parent or a guardian or someone 21 years old, and she was not. Now, at issue here was whether the daughter taking the vehicle with permission but without a valid license constituted an unlawful taking. Now, here in the Monaco case, the court noted that the first level of inquiry when applying this statute always concerns whether the taking of a vehicle was unlawful, and if the taking was lawful, the inquiry ends because the statute is inapplicable. Now, the court here drew a distinction between unlawful taking a motor vehicle and unlawfully using a vehicle, reasoning that obtaining possession of an object is very different from employing that object or putting it into service. So essentially the court said that although she may have unlawfully used the vehicle, she did not unlawfully take the vehicle, and that's the important distinction here with this Bradley v. Westfield case. The plaintiff may have been unlawfully using it, but she did not unlawfully take it. Now, moving on to the other case, the Court of Appeals highlighted the Swoop case. Here, plaintiff was in an accident while driving a car owned by a friend, and while there was no indication that she did not have the friend's permission to take the vehicle, she didn't have a valid driver's license, as with Kim Bradley in the Monaco case. Now, as the court explained in Monaco, the fact that the plaintiff had permission to drive the vehicle, to use the vehicle, should have ended the analysis. There was no unlawful taking. In Swoop, the panel eliminated the distinction between taking and operating. The entire analysis was under the heading titled Unlawful Operation, which is clearly different from what the statute MCL 500-3113 says, which is an unlawful taking. Now, ultimately, the Court of Appeals here opined that the insured did not procure her insurance policy via fraudulent induction because she was never asked by defendant to identify the members of her household and never represented to defendant that plaintiff did not reside with her, or she never represented that that plaintiff didn't use her vehicle either. Further, the rescission relied upon by defendant was not mutual, and the claimed basis for the unilateral rescission, i.e. fraud, could not be shown, which is that the cashing of the check. Now, because there was no rescission, the court didn't even go into the innocent third party doctrine and do any analysis with regard to that issue. And lastly, plaintiff operating the vehicle without a valid license did not constitute an unlawful taking pursuant to MCL 500-3113. It was just an unlawful driving of the vehicle, or unlawful using of the vehicle, not taking. Alrighty, moving on to trending topics in PIP litigation. Again, I wanted to discuss business auto policies, PIP benefits, and potential summary dispositions with regard to these policies. Now here it's important to look at the forms and the endorsement schedules, the coverages, and covered autos / specifically described autos. Now, in that deck page, or in the policy in general, mostly the deck page is where this information is contained. Only sometimes specifically described autos may receive PIP benefits, and you might have a situation where a plaintiff's attorney does not know the policy says that. So just because you have this business auto policy and an accident occurred by an employee does not necessarily mean that the specific insurer is required to provide coverage, because if only certain autos are covered for PIP benefits, then only those certain autos can obtain PIP benefits from the insurer. And if that's the case, there needs to be an inquiry as to who does insure that vehicle that was driven. Obviously, there are some issues regarding employer or independent contractor, and those need to be explored throughout discovery, mainly in the plaintiff's deposition. You have to figure out that economic reality test and figure out who actually had control over the employee / independent contractor. And if it was the employee / independent contractor, him or herself, then they were an independent contractor and not an employee, and therefore cannot obtain PIP benefits from the policy. Now, pursuant to MCL 500-3114, as we all know, it determines the order of priority when seeking no-fault benefits. As of June 2019, no-fault reform, the statute provides that the injured party must first look to their own insurance policy, then a spouse or relative, and lastly, the MACP. With employees, his or her spouse or relative domiciled in the same household may seek PIP benefits if they were injured while an occupant of a motor vehicle owned or registered by the employer. There are several words to really dig into here. Owned or registered by the employer. So that's the situation where even though they were doing work for the employer, maybe the employer did not own or register the vehicle they were driving. Also, employer, you can only be an employee if you have an employer, so no independent contractor. So it's important to dissect those specific words. Now, for purposes of MCL 500-3114 Section 3, whether an injured person was an employee is determined by applying the economic reality test, and that's the case of Aldenac v. Harco. This is still very good law. It's depending on a number of factors. So the more information you can get from a plaintiff during their deposition, the better. You have to go into things such as who pays for your gas, who creates your schedule, Do you pay taxes? Who pays for the maintenance of your vehicle? Do you take the vehicle home? Is this your vehicle? Do you have personal insurance on this vehicle? So all of these things, and the more facts that you can get to support your position that the plaintiff was an independent contractor, the better. So you just hammer away at the plaintiff asking all these questions. It's pretty much an exhaustive list, and you want the scales to tip in your favor, obviously. Specific to the Algonac case, the factors considered there were control of the worker's duty, payment of wages, right to hire, fire and discipline, performance of the duties as an integral part of the employer's business toward the accomplishment of a common goal. The court said in this case that while they have routinely cited those 4 general factors, they also recognize that no single factor is controlling. So that's why it's important to, like I said, go through that pretty much non-exhaustive list. I mean, I've asked a whole hour's worth of questions regarding the non-economic reality test to determine, and you never know which specific fact is going to tip the scale in your favor. And that is all I have for you guys for today. As always, please feel free to see me with any questions and or concerns. July 11th new case, I think is very persuasive and interesting, and it just shows that insurers need to create an encompassing application for insurance that asks a non-exhaustive list of questions if possible. Questions that you don't think may come up, but if you ask them anyway, you'll be able to look back and point to that. Thank you guys for listening.